Thank you, Mr. Speaker. I'm very pleased to have the opportunity to speak today at second reading on Bill C-43. It's described as an act for the faster removal of foreign criminals. I really don't think if we were debating the title of the act, there'd be anything to debate. I think that a lot of Canadians, I can't imagine any Canadian who doesn't think that a foreigner who's a dangerous criminal shouldn't be removed from Canada. The difficulty with the Act is, and this has happened lately with a number of the pieces of legislation brought before this House since I've been a member, I've been surprised how far they've morphed from the kind of titles of legislation I once studied in law school. It used to be you opened a statute and you found the book, not just the book was dusty, the title of legislation was just plain description, just a blanket description of what was at stake, immigration and refugee statute, or a law to deal with the Fisheries Act. Now we have titles that seem to come out of they probably don't just seem to, they probably do come out of focus group testing for legislative titles that will be zingers in future election campaigns. As someone who studied statutes, I find this a dismaying trend. I realized the other day while watching that U.S. program on HBO called Newsroom that this was invented first by the Republicans south of the border. I don't watch enough U.S. TV to have known that if I hadn't been watching Newsroom. Anyway, back to the topic. This piece of legislation, which amends the Immigration and Refugee Protection Act, definitely has merit if what it is about is getting rid of dangerous foreign criminals who have no right to be in Canada. I assert that what we have here, of course, is always going to be a question of balance. We don't want dangerous foreign criminals with no right to stay in Canada to be here, threatening Canadians who have every right to be here. But we also recognize that under the Charter of Rights and Freedoms, residents and citizens of Canada, permanent residents, have charter rights. And the question then is, have we got the balance right here? Are we protecting Canadians who are not a threat, or permanent residents who are not a threat to our society, and sweeping them up in a vast and sweeping discretion to the minister, which could do serious injustice to individuals who actually are important parts of Canadian society, who actually contribute in positive ways, and that we would not want to be caught up in a sweep that didn't take account of individual rights, individual situations, humanity, compassion, and holding families together, and other aspects that have always been part of the consideration before a deportation takes place. Now, when we ask if the balance is right in this legislation, I'm going to turn to some of the recent comments by members of the Canadian Bar. Toronto lawyer Mendel Green is quoted in this story from the Toronto Sun as saying, quote, "I am concerned about the monumental effect this will have on the immigrant community if it becomes law. This will be a life sentence for many people," unquote, Mendel Green. Lawyer Joel Sanderlook, at the same press conference representing the Ontario Criminal Lawyers Association, said, "This will destroy families who've been here a long time. It will create more criminals if parents or other family members are removed from Canada." Further quotes from other lawyers, lawyer Gidi Maman also said, quote, that the potential Canadians or Canadian residents who could be swept up and deported with no chance of appeal and without any exercise of individual discretion include, quote, "These are young children brought to Canada at a young age as permanent residents, raised and schooled in Canada, but never took out citizenship. It is unconscionable that a country like Canada, which has always allowed for second chances, to now embark on a new one strike, you're out approach." And lastly, I'll cite lawyer Andrew Schreck, Vice President of the Ontario Criminal Lawyers Association, who said that this law is drafted in such a way that it could quite easily sweep up people guilty of minor offenses and have them deported. In his words, quote, "We're not talking about serial killers, murderers, or bank robbers." Now, let's take a look at what kind of people could be swept up and what kind of crimes could be committed to be considered as having committed a crime for which there's no right of appeal. They're just going to be sent out of the country. This can be as described as crimes where someone is convicted for a sentence of 6 months or more. Now, the current law deals with crimes where sentences are 2 years or more. So bringing it down to 6 months or more for a crime for which the ultimate sentence could be as much as 10 years in jail really is bringing in a series of crimes that don't actually threaten the security or at least the safety of Canadians. In other words, it takes in a number of crimes that don't involve any threat of violence. In other words, not anywhere in this act, before deporting someone if they've been guilty of a crime committed and sent to jail for 6 months or more, nowhere in this new legislation is it required that that crime be a crime of violence or something that threatens the security of Canada. The kinds of crimes that they've listed that I found that might in fact fit this definition, for which you could get a 6-month sentence but a 10-year maximum, would include you could be, as a permanent resident, deported for possession of a stolen or forged credit card and use of that credit card knowing it had been canceled, unauthorized use of a computer or forgery, and a host of other offenses that carry 10-year maximums. Now, in that case, we're talking about no discretion, no appeal, and that in fact what could easily happen is that it could be a younger member of the family, a parent. So the fact that you're part of a fabric of a Canadian family, children born in Canada, relatives participating in Canadian society, any one member of a family guilty of something which is not in any way a crime of violence, if it's a 6-month sentence with up to a 10-year maximum, you're gone. You don't have a chance to plead your case. Now, I'm going to quote one other lawyer on this matter, and that I'm very proud to say is the current nominated candidate for the Green Party in Victoria in the by-election. His name is Donald Galloway. He's a founder of the Canadian Association of Refugee Lawyers and is also a professor of refugee and immigration law at University of Victoria. And in looking at this, he suggests that what we have, and I'm paraphrasing a bit, but there's an inherent legal balance built into the current Act, into Section 34. So the courts have accepted broadly defined prescribed grounds of inadmissibility that are found in Section 34(1), based on the assumption that these same sweeping inadmissibilities are balanced by the provisions of 34(2). What this new law, what C-43 will do if enacted, is to fundamentally destabilize the legal balance by removing the layer of individualized, personalized, case-by-case review, guided by, in some cases, humanitarian concerns and compassion, that acted as a safeguard against the breadth of prescribed grounds for inadmissibility found in Section 34(1). Beyond issues of compassion and fairness, this ill-conceived change will force the courts, as they have already indicated, into a position where they are going to need to intervene and fix this Act to provide a reinterpretation to ensure that this Act remains constitutional. Otherwise, it's going to violate the Charter. Now, I want to just turn my attention, before I run out of time, to another section that I find particularly egregious, which doesn't deal with criminals. It doesn't deal with people already in Canada. But if the minister, under the new Section 8, which changes Section 22 of the current Act, is dealing with a foreign national who has applied to become a temporary resident of Canada, the minister has unfettered, under this new provision, very unusual, unfettered discretion to make a decision to refuse that person the right to be a permanent resident of Canada with no criteria whatsoever, no objective criteria that can be measured. There's, let me just read the language. Section 22(1), which you find under Clause 8, Mr. Speaker, under this new C-43, allows the minister, on the minister's own initiative, to declare a foreign national that may not become a temporary resident if the minister is of the opinion that it is justified by public policy considerations. And this banishment can last for up to 3 years. Now, going back to my time in law school and legal drafting and statute interpretation, you don't find anything that gives you more freewheeling power to make up your mind which way you want than the language, minister is of the opinion. No court's going to be able to step in and say, well, we don't like the way the minister exercised his discretion or her discretion, because this will apply for all time. I'm not speaking of the minister at the moment. This is a permanent change to our legislation and a dangerous one. This says the minister is of the opinion, and then what? What is the minister of the opinion? That it's justified by public policy considerations. Again, you couldn't come up with something that gave you more freewheeling discretion, not bound by anything in particular. What kind of public policy considerations? Well, maybe the public policy consideration that we think we have too many of a certain kind of person in a town. Who knows? It's without objective criteria. So, Mr. Speaker, I hope that when this legislation goes to committee and is studied in committee, we can rebalance the balance that must be there. I stand here before you as leader of the Green Party, not in favor of keeping dangerous foreign criminals in Canada, but in keeping the Charter of Rights and Freedoms in Canada. Thank you, Mr. Speaker.
Questions and comments? Questions et commentaires? L'honorable député de Vaudreuil.
The honourable member for Vaudreuil-Soulanges.
I share many of the same concerns with the member from the Green Party. I do have the question, I'm not clear whether she will support this bill going on to committee. For instances, say if a war criminal was found, convicted war criminal, and questions like that. And would she not also agree with me that there's a question of priorities here with the government presenting this bill before the House when there's so many other problems that exist? Underemployment of new Canadians costs us $5.9 billion a year in losses because of their underemployment. We've hollowed out our foreign engagement, eliminating culture as a pillar of foreign policy, so we don't meet them on their soil anymore. We've hollowed out the system to integrate professional new Canadians, and now we've hollowed out Canadians' trust in new Canadians. So does she not agree with me that perhaps the government's priorities are misplaced, that even though we are supporting this at second reading, and we hope that she will join us in order to improve the bill at committee, does she not see a question of priorities?
The honourable member for Saanich Gulf Islands.
And I thank my friend from Vaudreuil-Soulanges for the question, Mr. Speaker. You know, with not just some, but with a lot of concern and mixed feelings, I will support sending this bill to committee. I'm not a member of that committee, and I will reserve the right I have as the member of the representing the Green Party here and representing Saanich Gulf Islands to submit amendments at report stage if I'm not satisfied that the bill has been rebalanced appropriately to reflect the Charter of Rights and Freedoms and respect for it. His question about war criminals is a good one. I mean, it sounds pretty much like a no-brainer. If someone's a war criminal, you don't want them in Canada. If someone's defied their government and committed crimes and spent time in jail. But every now and then a person like that gets honorary Canadian citizenship, like a Nelson Mandela. So the move under this legislation and other legislation, such as the mandatory minimums under C-10, the move is towards an authoritarian, automatic discipline which is unforgiving forever and lacks any compassion or humanitarian or even a thought process. And that I will always oppose.
Questions and comments? The honourable member for Edmonton Centre.
Well, thank you very much, Mr. Speaker, and I'm sure she didn't mean that, but I don't think she meant to refer to Nelson Mandela as a war criminal. But beyond that, and I'm sure she didn't mean that. You know what? When I talk to immigrants in Edmonton or anywhere else, they are some of the ones who are the most upset at others who come from abroad to be part of Canada as landed immigrants or permanent residents, whatever. They're some of the ones who are most upset about the people who get away with serious crimes. You know, get away with murder is the expression that is true in some cases, a little extreme in most. But they're some of the ones who are the most upset about others who don't play by the rules, others who take advantage of Canada's generosity. Some would suggest over-generosity. Nobody suggests taking away somebody's rights or somebody's ability to appeal, but not to appeal endlessly for 7 to 10 years, time after time after time, when the evidence is clear. And it's simply the immigration industry prolonging this process. And it's immigrants themselves who are the most upset when I talk to them. They play by the rules, and they expect everybody else to play by the rules. Existing Canadians, natural-born Canadians, or new Canadians.
Honourable member for Saanich Gulf Islands.
Thank you, Mr. Speaker. I thank my honourable friend for Edmonton Centre for catching me on that. I certainly didn't want to refer to Nelson Mandela as a war criminal. My point is that his history is written by the victors, and quite often you could find someone accused in another country called a convicted terrorist, called something that we would not want in Canada. But if you lose your ability to examine the particular circumstances, you lose your ability to think, you lose your ability to be truly Canadian. And I believe that what we want to do with this legislation is consider all of the ways in which it can go awry from what I'm sure is the Minister's intention of bringing this forward. A family that's been in Canada for a long time with kids who've been in Canada for a long time, and someone finds themselves convicted of misuse of a credit card or of a forgery, this is No more chances, you're deported. And that can't be the Canadian way.